We've brought in legal expert Ulrich Roux from Ulrich Roux and Associates just to weigh in on these developments and that particular court case. Ulrich, a very good afternoon to you and thank you so much for your time. Let's start with you just helping us place Advocate Tefo here. I mean, he's requesting to be the friend of the court. He's detailed how dangerous the applicants are, particularly Lieutenant General Khumalo and of course some of the accused. How will this affect this case and also just his involvement here?
Hi, good afternoon. Thank you for having me. Well, it shouldn't affect it whatsoever. The current status quo at the moment is that a magistrate has recused himself from a matter. He's found that the fact that he has been mentioned in the same commission means that he could be biased and that he's not allegations could be thrown at him that he's not acting in an objective manner, and accordingly he's decided to recuse himself. So the fact that Advocate Tefo has declared himself as a friend of the court now should not impact that. The NPA have indicated that they want to take the magistrate's decision to recuse himself on review, which means that they need to approach the High Court in order for the High Court to determine whether that decision was indeed the correct one that the magistrate recuses himself. So one now needs to wait and see whether the High Court agrees with the magistrate's decision for him to recuse himself from the matter. We've heard that the accused obviously are not satisfied with that, and they are adamant that their application to have their bail conditions amended is of an urgent nature and that it should proceed. The magistrate, however, said that the review application must first be finalised before that can be the case. So they are, in a sticky position. In my view, the only way that they could progress their application to have their bail conditions amended is to approach the High Court on an urgent application. Any bail proceedings are urgent in nature, and I do foresee that the High Court would entertain such an application in order to determine whether their bail conditions can indeed be relaxed or not, in order for them to attend to their place of employment, obviously with the South African Police Services. So one now needs to wait and see whether their legal representatives indeed do approach the High Court on an urgent basis, or whether they wait until the 6th of November for more clarity from the Magistrates Court. I can, however, confirm that a review application will definitely not be finalised within this year. So they would be looking at quite an extensive delay in the matter should they wait for the High Court to first entertain that review application.
Okay, you've answered a number of my questions, including, of course, IDEC being of the view that the magistrate should not, recuse himself from the matter. Very quickly, if you can expand, in the application to have Khumalo's bail conditions relaxed, Mshololo counsel here argued that the applicants are not able to go to work under the existing conditions despite clearance from the National Commissioner. I mean, your take on that argument?
Well, of course, the charges leveled against the accused do emanate from their place of employment. So one can see why the state is hesitant for them to return to their place of employment, because a full investigation needs to be conducted. And the state obviously wants to prevent the accused from influencing any of the employees within their divisions in the South African Police Services. So one can understand that. But again, it is a constitutional right to be able to work. And should the accused make out a strong enough case, and should adequate conditions be imposed on their return to their employment, one could foresee that a High Court would agree with him. But one now needs to wait and see whether that is indeed the case.
And just very quickly, as we wrap up, just in terms of when this case does resume in November, how, if at all, will the ongoing probe into Mkhwanazi's allegations factor into the court's decision, as we have been hearing testimony specifically from Mkhwanazi himself about how these charges are used to stop Kumalo and discredit him. And we've been also hearing a little bit more about, the crime intelligence from other testimonies that we've been hearing also in the ad hoc committee.
Well, the charges are still being investigated, which means that the South African Police Services are still fully within their rights to accumulate any evidence which they feel is applicable to this matter and which could assist the state in proving their case and obviously demonstrates any wrongdoing on behalf of the accused. So it is very much relevant if there is factual evidence that they could use to their benefit, and the South African Police Services certainly will do so. On the other hand, any magistrate or judicial officer who oversees a matter should not be influenced by any outside influence, and the matter should be adjudicated purely on the evidence before the court. So one can expect still, a lengthy investigation taking place in this matter, and definitely I do foresee that some of the evidence that comes out of the Mahlangu Commission would be used in this matter if there are credible witnesses that do come forth, and if there are factual evidences obtained from these witnesses which the state can use in attempting to prove their case. So definitely applicable, yes.
Interesting. Thank you so much, Ulrich, for your time. Ulrich Roux there from Ulrich Roux and Associates, just weighing in on that particular court case.